The modern enterprise is often defined less by the physical land it occupies and more by the creative and innovative output of its workforce. We are defining the four main types of intellectual property to help you protect your organization's creative assets from unauthorized use or theft. Typically, the value of a high-tech company resides almost entirely in its ideas, which requires a specialized set of legal and technical guardrails to remain secure. In practice, a cybersecurity professional must understand these distinctions to ensure that the appropriate security controls are applied to the right categories of data. What this means is that we are expanding our view of protection beyond simple bits and bytes to the underlying legal concepts that represent the true wealth of the organization. Before we continue, a quick note. This audio course is a companion to our course companion books. The first book is about the exam and provides detailed information on how to pass it best. The second book is a Kindle-only ebook that contains 1,000 flashcards that can be used on your mobile device or Kindle. Check them both out at cyberauthor.me in the Bare Metal Study Guide series. Intellectual property is a broad field that encompasses four distinct pillars, specifically patents, trademarks, copyrights, and trade secrets, which each have unique legal protections and professional rules. Each of these categories serves a specific purpose in the marketplace, ranging from the protection of a brand's reputation to the safeguarding of a complex mechanical invention. In practice, the methods used to secure a trademark in a marketing database are vastly different from the high-security encryption required for a multi-million-dollar trade secret. Typically, an organization will hold a portfolio of all four types, creating a multi-layered shield around its business model and its technological innovations. Understanding how these separate laws function is the first step in building a comprehensive and legally sound protection strategy. A very helpful way to internalize these categories is to practice by identifying one specific example of a trademark and one example of a copyright within your current office or workspace. You might see a brand logo on a laptop or a distinctive product name on a coffee mug, which both represent the protected identity of a trademark. At the same time, the employee handbook on your desk or the specific lines of software code on your screen represent original creative works protected by copyright. In practice, recognizing these assets in the real world helps to demystify the legal terminology and reinforces the idea that intellectual property is everywhere. Typically, the objects we interact with every day are a complex patchwork of different legal rights and protections. A common and highly confusing mistake in professional communication is using the terms patent and copyright interchangeably, even though they protect very different things. A patent is granted for a new and useful invention, such as a hardware component or a unique chemical process, providing the owner with the right to exclude others from making or selling it. A copyright, on the other hand, protects original works of authorship, such as books, music, and computer software, focusing on the expression of an idea rather than the invention itself. In practice, failing to distinguish between these can lead to the implementation of incorrect security policies or the filing of flawed legal documents. Typically, a seasoned professional understands that while both protect creativity, they operate under very different sets of rules and timelines. You can achieve a significant and immediate quick win for your study plan by creating a simple, one-page chart that lists each intellectual property type alongside its primary purpose and a classic business example. This chart acts as a mental map, allowing you to quickly categorize any new piece of information or project that comes across your desk. In practice, having this summary available during a meeting with the legal or engineering departments ensures that you are speaking the correct professional language. Typically, these visual aids are highly effective for reinforcing the specific legal requirements for each category, such as the need for novelty in a patent or originality in a copyright. What this means is that you are building a structured foundation for your advanced governance and security decisions. It is worth taking a moment to visualize your company's brand name and its distinctive logo as a trademark, while simultaneously viewing its proprietary software code as a copyrighted work. The trademark protects the goodwill and the identity of the business in the eyes of the consumer, ensuring that no one else can confuse the public by using a similar name. The copyright protects the specific technical labor and the creative expression involved in writing the instructions that make the software function. Typically, a single product, like a smartphone, is protected by a combination of thousands of patents, dozens of trademarks, and millions of lines of copyrighted code. In practice, this visualization helps you understand that a cybersecurity incident often impacts multiple types of intellectual property at the same time. In the fields of finance and law, we use the specific term intangible asset to describe the immense value of ideas, processes, and creations that lack a physical or corporal form. Unlike a truck or a server rack, an intangible asset cannot be touched, yet it can be sold, licensed, or stolen just like any piece of physical property. In practice, the protection of these assets is much more difficult because they can be copied perfectly and distributed globally in a matter of seconds. Typically, the evaluation of a modern company is based primarily on these invisible rights, making their security a top priority for the board of directors. What this means is that your role as a protector of data is directly linked to the protection of the company's most valuable financial and strategic assets. Reviewing the specific duration of each intellectual property type ensures that you know exactly when a protection might eventually expire or lapse into the public sphere. For instance, a utility patent generally lasts for 20 years from the date of filing, while a copyright for a corporate work can last for 95 years from its first publication. In practice, once these protections expire, the organization can no longer prevent competitors from using the technology or the creative work for their own gain. Typically, trade secrets are unique in this regard, as they can theoretically last forever as long as the information remains secret and is protected by reasonable security measures. This understanding of legal lifespans allows the organization to plan for the future and to prioritize its defensive efforts effectively. Imagine a challenging and high-stakes scenario where a major competitor steals your unique and highly efficient manufacturing process because you failed to protect it as a formal trade secret. If the organization did not implement the necessary technical controls, such as non-disclosure agreements and restricted access, a court may rule that the information was not a secret at all. Typically, once a secret is lost or becomes public knowledge, its legal protection vanishes instantly and cannot be recovered by any means. In practice, the loss of a key trade secret can lead to the total failure of a business or the loss of its primary competitive advantage in the market. This scenario highlights why the technical and administrative reasonable measures you take are the only things that give a trade secret its legal power. Every professional should anchor their understanding of this domain in the fundamental goal of using the right legal and technical tool to safeguard each specific business innovation. You would not try to protect a brand logo with a patent, nor would you try to protect a new hardware circuit solely with a trademark. In practice, the legal team and the security team must work together to identify the crown jewels of the company and determine which IP framework provides the best defense. Typically, a mature organization uses a blend of all four types to create a picket fence of protection that is difficult for any competitor to overcome. What this means is that your technical security decisions are the essential enforcement mechanism for the organization's high-level legal rights. We have now explored the primary definitions and the strategic importance of the different categories of intellectual property law that define the modern business landscape. By understanding how patents, trademarks, copyrights, and trade secrets function, you are building a more resilient and self-aware framework for organizational protection. Typically, the most effective practitioners are those who can spot an intellectual property risk during the early stages of a project and advise on the proper safeguards. In practice, this integrated perspective ensures that the organization remains a trusted and reliable owner of its innovations and its brand identity. This focus on IP differentiation is what ensures that your security program is a verified and trusted reality for the executive leadership. In the study of creative rights, we use the concept of the public domain to identify works, ideas, and inventions that are no longer protected by intellectual property laws. Once a work enters the public domain, it can be used, copied, and modified by anyone for any purpose without the need for permission or payment. In practice, works enter this state either because the term of protection has expired or because the creator has explicitly dedicated the work to the public. Typically, Knowing which assets are in the public domain helps the organization avoid unnecessary licensing costs and clarifies which of its own assets must be guarded with the most intensity. What this means is that you are identifying the open parts of the digital world to better focus on the closed and proprietary ones. Differentiating these types correctly is the absolute first step in building a comprehensive and professional strategy to defend your company's long-term enterprise value. When you can accurately classify an asset, you can apply the specific security controls required by law, such as the reasonable efforts needed to maintain a trade secret. Typically, a team that speaks the language of IP is much more effective at communicating risk to the board of directors and the legal department. In practice, the energy you spend on mastering these definitions today is a direct investment in the long-term stability and security of the organization's most valuable innovations. This focus on detail is what ensures that your organization remains a respected and legally sound leader in the global digital economy. This introductory unit on differentiating intellectual property types is now complete, and you have gained a solid understanding of the primary pillars of legal protection for creative assets. We have discussed the definitions of patents, trademarks, copyrights, and trade secrets, the role of intangible assets, and the importance of understanding the public domain. A warm and very practical next step for your own professional growth is to take a moment today and find the official trademark symbol, the small TM or the circle R, on a product in your office. As you look at it, consider the brand identity it represents and the technical and legal work that goes into protecting that identity from competitors. Moving forward with this observant and disciplined mindset will help you become an expert at protecting what matters most to your organization.
Thanks for listening. For more audio courses, daily newsletters, and more, please visit baremetalcyber.com.